Chapter 10, Negotiating Agreement. So in this chapter, we're going to talk about the various aspects with regards to negotiating an agreement. First is the developing a negotiating strategy. Many of the day-to-day experience are shaped by negotiations, and often there are various outcomes that are possible with every negotiation. There is a win-win where everyone's objectives are met in a positive manner. The seller obtains the market price and the buyer receives the sought after property. Win-lose, where the seller wins by successfully selling his house or at or closing or close to the asking price. So by disregarding certain problems with the property, must make significant repairs after taking possession. I mean, and so like similar to win lose, there's a lose win as well, where the seller loses and buyer wins. And there's a lose lose where both buyer and seller fail to achieve a meeting of the minds and everyone loses. The seller misses the opportunity to sell the house to the best buyer, and buyer fails to get the desired property. And of course, there's another outcome which is like no outcome, and in the no outcome case, the seller decides not to sell, and the buyer exits having second thoughts about the financial commitment. So again, the no outcome is different from a lose-lose, where a lose-lose is when both buyers and sellers fail to go ahead with with the transaction. No outcome is when the sale is postponed, and again, it's a case of no outcome. Both parties may renegotiate at a later time, or maybe advance to other win situations. So one of the key criteria of a negotiating strategy is to have more of a have a behavior of a solution listening, be a creative listener, become a solution maker. When in doubt, ask more questions, and also to make sure that other than the selling price, uh, make sure that the seller understands that there are other things than just the price. Um, because negotiation thrives on interlocking issues, not just as and not isolating a single circumstance. A few $1,000 separating buyer and seller is just one piece of the puzzle. Preparing for the offer presentation. Preparing for offer presentation cannot be a hit and miss affair. There's a whole lot of preparation that is required for the offer presentation. Initial preparation: once the offer has been signed by the buyer and is ready for presentation, the listing salesperson requires certain information to assist the seller in making an informed decision. Buyer representative may also contemplate selected item discussed below in preparing for their role in the presentation process. Review the listing file, summarize marketing activity, update comparative market analysis, review buyer's information, and prepare the seller net. So going back, so what does the reviewing the listing file means? So any offer should be examined in the light of the terms under which the seller agreed to market the property. Circumstances may also have changed since the property was originally listed. So it's important to go back to review the listing file. Summarize marketing activity. Summarize information such as frequency of advertising, responses, number of showing, previous offers, and open houses conducted. It's always useful to give comments received from the buyers. Update the comparative market analysis. Prepare and update the comparative market analysis showing recent sales and properties that remain unsold. Review buyer's information. Information provided by the selling brokerage concerning the buyer can provide additional important background details that will assist the seller in making a decision. Prepare the seller net. Advanced preparation of financial information can assist the seller regarding appropriate selling costs and net proceeds if the offer is accepted. The offer preparation checklist. Uh, the checklist basically consists of 6 items: the deposit, make sure that the deposit is sufficient, and the larger the deposit, the greater is the security for the seller. Closing or the completion date. Non-alignment of the buyer's completion date with that of the seller can be the focal point. So because you might need an interim financing in case the seller has to sell his current home, and the buyer before buying has to sell his current home as well. So in opposing situation, the seller may be asked to vacate the premises prior to the new property being ready for occupancy. Chattel included and feature excluded. This is more of a debate, and an agreement needs to happen on the chattels which are included and the fixtures which are excluded. Financing: if the mortgage is taken back by the seller, then the seller's take back presentation should be anticipated. Be prepared to fully discuss the option and assist the buyer in making the decision. Price: seller tend to look at the price of an offer and react emotionally to it without examining the other terms and how that will impact the overall price. And the other issues would probably be how this offer compares with the others, or salesperson's original advice, and or the other offers that seller had rejected. Making an appointment. So, since every offer sets a time limit on the acceptance, and the offer may no longer be accepted upon expiration of the time limit, buyer who executes such offer has the right to expect that the salesperson involved will be present at the earliest possible time. So again, time is of essence, and it's obviously in salesperson's own interest to present the offer of acceptance as promptly as possible and to expediently communicate acceptance if given back to the buyer. Right to legal advice. Seller and buyers must be protected from accepting terms in an offer that are not they are not able to perform, or terms over which they have no control. The lawyer is in the best position to advise the seller whether he or she can freely accept the offer, or and is in a position to fulfill the terms stipulated in the offer. Such legal advice should be independent representation. Several points concerning legal advice are as in seller and buyer have an absolute right to independent legal advice. In certain circumstances, salesperson should assist the client obtain legal advice. Salesperson should not hesitate to advise the seller of a concern about the condition or the matter that are not completely understood. Seller has the right to full disclose to any and all the information known by the seller representative based on code of ethics. While a salesperson may act in advisory capacity to extent his ability, he or she should advise his kind of customer to obtain services from an appropriate expert. Offer presentation and acceptance. Offer presentations are often a challenge for a new salesperson. Make certain that the local methods and policies are fully understood. Be particularly cautious with multiple offer presentation. In some cases, well-established presentation procedures have evolved. For those joining organized real estate board rules and regulations apply. Equality the client. The client interest must always be promoted. The client may make the final decision regarding the offer acceptance and rejection, but the sales representative duty is to make him or her aware of the relevant facts and assist in rendering an informed, rational decision. Many negotiations fail due to the inadequate or poor presentation, poor offer presentation, and preparation. In particular, knowledge is vital. The real estate sales the real estate negotiation involves opposing interest. The listing salesperson advances the seller's interest, and the negotiating stance selling salesperson drafts an agreement to advance the buyer's position, and as such may conflict with the seller's best interest. The selling salesperson usually brings the buyer's offer to the listing salesperson, and so attending the presentation, the relationship between client and the broker is of utmost. Disclosures, disclosures leading to the preparation of agreement has been detailed in the previous chapters. But again, there is information before the agreement. There is information for multiple representation, and the disclosure of interest. So registrants must provide certain information as soon as practically possible and before the agreement is entered with respect to treating real estate like seller or buyer representation agreement. Registrant must disclose matters concerning multiple representation before both when entering into the agreement in respect of real estate, and also prior to an offer to purchase is being made. The agent must disclose matters concerning any personal interest in the acquisition or disposition of property, or indirect or indirect financial benefit like a fine or fee. Offer to purchase real estate. Given the requirement of REBA 2002, only written offers are acceptable. So a registrant cannot represent to anyone that an offer has been received until it is in writing. With regards to conveying offer, the Code of Ethics requires that the offer be presented at the earliest practical opportunity, and also stipulates that another agent must be available should the broker or salesperson be unable to attend the presentation. Presentation order or acceptance. Salesperson Lee of ABC Realty lists Mr. and Ms. McGill's property, and salesperson Martin of ABC Estate prepares an offer. So the way it works is Martin will call the Lee, and the Lee is going to call the seller to arrange for a convenient time and location, typically at the seller's home. Then the buyer's agent is going to call the seller's agent to confirm time and location. So they're going to come to the seller's home separately. Then the buyer's agent is going to present the offer. The seller might make a decision in principle of the salesperson, or might request a private meeting with their agent. Assuming the offer is acceptable, the seller signs, dates their signature, and either of the seller signs the confirmation of acceptance. The seller's portion of the acknowledgement is complete and signed by them. So first the seller is going to sign the confirmation of acceptance, and then they're going to sign the acknowledgement. Then the salesperson, both buyers and sellers, sign the commission trust agreement, and the signed copies are distributed to the sellers. Then the buyer's agent takes the balance of the signed offer to communicate the acceptance to the buyer, distribute the copies, and completes the buyer's portion of the acknowledgement. And once everyone has signed, Martin retains a copy for XYZ real estate for his brokerage, and delivers the listing broker's copy with fully complete acknowledgement to the salesperson. Signed copies are also forwarded to the lawyer as a matter of accepted business practice. Now, in case of competing offers, a registrant must disclose the existence of other offers without divulging the substance of such offers. Offers are typically present in the order in which they are received. Three possible actions are possible. Three possible actions, and the consequences are are for example, if the seller accepts one offer, then and the remaining buyers look for the property. Seller counters offers. Buyer can wait till the last moment and decide not to accept it, and the seller rejects all the offers and advises buyers to reconsider their position. So in the third case, where the seller rejects all the offers, the buyers might or might not participate in the subsequent rounds. Negotiation and risk. So client needs full awareness of the pitfall regarding certain innovative marketing techniques. For example, sharp bid, like willingness to pay a stated sum higher than any other offer presented. Another creative pricing clause may be dangerous, and it should not be considered without independent legal advice. An happy client is potentially a litigious client. At the same time, buyers can improve their negotiation position by impacting factors within their immediate control. Buyers may forego chattels, make a higher than usual deposit, provide a certified check with the offer, adjust the completion date, or offer other concessions that would make their offer more appealing to the seller. The acceptance: when the offer from the buyer is acceptable, the seller will sign and date his signature and sign the confirmation of acceptance. The acknowledgement is completed and signed, and the commission trade agreement is filled out. copy of the agreement is provided to seller immediately, and the balance of the signed agreement is taken to the buyer. Now, in case of a counter offers, can be made by either party. Typically, the buyer offers, and if the original offer is not acceptable, the seller can make a counter offer with changes to the unacceptable conditions or terms, like price, possession date, or financing, or the other terms. A counter offer is offered to sell with this with the seller and the buyer roles, and the buyer and seller roles get reversed. Now the seller is now the offerer. Three types of counter offers are such as possible: amend the original offer, prepare a counter offer form, or draft a new offer. And now, in case of amending the original offer, we insert amendments and initials. And when preparing a counter offer form, separate counter offer forms are filled out, and drafting a new offer significantly alters the terms, and handwritten changes are difficult to insert, in which case a new offer is made. Retaining copies of the offer. Copies of each offer received by the seller brokerage must be retained by the brokerage. If the buyer is declined and the customer of or a customer of the brokerage and the offer is not accepted, then the seller brokerage may retain a summary document rather than the entire offer. A counter offer. So in case a counter offer form is prepared because amendment is not possible, then we can use the counter offer form or a form 107. Sales related documents. Sales related forms can be involved at various points, from listing to final closing and mutual release. In the case of cancellation, ORA forms are used for illustration only. Brokerage policy may require a confirmation of cooperation and representation in advance of offer presentation. A trade record sheet must be prepared for the transaction, formerly referred to as a trade. Following the sale, amendment may be required and condition waived. If the sale falls through, appropriate forms must also can be used to terminate the agreement. So let's look at the common sales related forms. Like I mentioned, confirmation of cooperation and representation forms, or form 320, trade record sheet for form 640. Amendment to the agreement. Amendment to the agreement is form 120. These are like sales related documents. Notice to remove condition, which is form 121. Waiver is form 123. Notice of fulfillment of condition is form 124. And mutual release is form 122. So mutual release does the formal release of the obligation. Let's go into each of them in details. For the trade record sheet, which is a form 640, Real Estate Business Brokerage Act 2002 requires that a trade record sheet (TRS) be prepared for every trade. Trade record must be completed regardless of whether the deposit is received or not. Both listing and cooperating brokerage complete the trade record sheet for a single trade. Trade record sheet form 640 meets all statutory requirements. Brokerage may use expanded computer generated versions provided they can statutorily contain all the required information. Trade record sheets are focal both for regulatory control and also as a data source for management summary reports, and brokerage tracking systems concerning everything from commission receivables to trust account status. Initial processing, complete trade record sheets are signed by salesperson along with the broker or record. Practices vary concerning copies for salesperson. Some include all salesperson splits in one trade record, while others print separate sheet records for each salesperson as a matter of confidentiality. Trades are numbers consecutively and are usually assigned automatically by the brokerage software. Banking records related to the trade are cross-referenced to assign trade numbers. Real estate commissions are subject to harmonized sale tax. Selected questions are also answered. So a trade record sheet is going to have is going to have the seller and landlord. It's going to say name of the brokerage, date, name of the salesperson, um, sold the property details, seller and the buyer, corporating, listing, brokerage, um, and total consideration for the transaction, completion date, deposit, property other than the money held in trust, total commission, HST, and total receivable commission is all put it out. Pending sale filing is other items like pending sale filing, handling the deposit closing procedures, drafting guidelines. And the other item is to talk about after sales ready document is the sale and privacy documents. The three information type: personal information and sensitive personal information and personal facts. So personal information and sensitive personal information are covered by the privacy legislation like PIPEDA, and personal fact which are non-identifiable and anonymized. The Privacy Commission established under the PIPEDA as the omnibus for complaints under the Privacy Code. ODIA has the Privacy Code based on the personal information legislation PIPEDA. Privacy Code is a set of principles providing guidance for to the members of the organized real estate in collection, use, and disclosure of the personal information. Purpose and consent reason for collecting information must be identified. All the brokerage firm policies are available, and salesperson files and records also need to be updated. That's all for this. Thanks.